Good morning, everyone, and welcome to a special session of Meaford Council. It's not our usual hour, and today we are going to be enjoying some special training on the Drainage Act and also Court of Revision for councillors. And I think everyone will find this quite interesting and valuable information. I'm going to begin by asking Deputy Mayor Keaveney to read our land acknowledgement.
Good morning. We would like to begin by acknowledging that we are meeting on the traditional lands and treaty territory of the Saugeen Ojibwe Nation, which includes the Chippewas of Nawash Unceded First Nation and the Chippewas of Saugeen First Nation. We also recognize the Métis, whose ancestors shared this land and these waters. We extend our gratitude to all Anishinaabe and Métis peoples and their descendants, past, present, and future, who continue to care for and inhabit these lands and tend these waters.
Thank you, Deputy Mayor. Now I'll just ask you to join us in a moment of silent reflection on today's matters. Thank you. Is there any disclosure of pecuniary interest? Seeing none, just remember that you can bring it forward at any time it occurs to you. So now I'm going to introduce Sid van der Veen, a planning engineer for R.J. Burnside and Associates Limited, who is going to give us some training on the Drainage Act. Sid, welcome again. We've been pleased to have you in the past, and I think we're ready for a refresher.
Thank you, Mr. Mayor. I do appreciate the opportunity. And yeah, it was about 2 years ago that I came here and gave a Drainage Act 101. This is going to be a refresher of some of that information, but expanded to also include some training on your duties as Court of Revision members. And I spoke to the mayor in advance, and he has graciously indicated that we are allowed to be informal. So if you have questions as I go along, please don't wait to the end. Do them as we are approaching or dealing with that particular subject matter. I have worked for Burnside for about 6 years now, but I have not been involved in the particular project. I don't have a copy of the report, so I will not be answering any technical questions. I really know very, very little about the project. Just a little bit more on my background. Prior to working for Burnside, I worked for the Ministry of Agriculture, Food and Rural Affairs as drainage coordinator. So I administered the Drainage Act for across the province, assisting engineers and municipalities and running the grant program as well. And I also did training courses at that time, and I continue to do training courses on the Drainage Act. So there's my background on the subject matter. Today, I'm going to talk a little bit about why do we have a Drainage Act in the first place? What's the basis for it? Then I'm going to give a bit of a petition drain process overview to explain how the process works. A little bit on drain management. I might cut that out if we get short on time. And then I'm going to get into Court of Revision training on what the duties are for you three, on what your job is as Court of Revision members. And also the types of appeals and understanding assessments, like the engineer's report has different types of assessments, and what does that mean, and why does the engineer actually include that sort of thing. So with that, I'm going to get going on it and say, what's the purpose of the Drainage Act? And that's really an introduction to common law. There's two types of law that we have in Ontario: statute law and the common law. And statute law is easy. Or relatively easy. It is the law that is passed by our federal or provincial governments, and it covers some specific subject matter, like the Municipal Act or the Highway Traffic Act, or you name it. There's all sorts of them. Fisheries Act, if you're a dairy farmer, the Milk Act, the Highway Traffic Act. Oh yeah, got that one up there already. So it covers some specific subject matter. Common law is completely different. It is the older form of law, and it was inherited from Great Britain, and it's all based on court cases. So it's not like statute law where you can open up a piece of legislation and read what it says. You actually have to research court decisions, and there are books that are written on common law. So it covers a variety of different subject matters, and I'm not familiar with all of them, but I am familiar with the common law as it relates to drainage. Common law always applies unless it's altered by statute law. So the way I look at it is common law is kind of our foundation, and we build statute law on specific subject matters on variety of different subjects. So again, common law applies to everything. I've indicated before, and this makes absolutely no sense, but I could sue my neighbor because he parked a pink Volkswagen in his driveway and it obstructs my view. I'm not necessarily going to be successful, but I can sue my neighbor about just about anything. And again, doesn't mean that it would be successful. I'm going to go through the common law principles as it relates to drainage. So here's what I was talking about, the common law kind of forming the foundation, and then statute law built on top of that. So the common law can still apply, but it may be altered or overridden by statute law. So what does the common law say with regard to natural watercourses? And this is information that may be important to you or useful to you beyond just this particular drainage project. What does the court say with respect to natural watercourses? Well, first of all, it defines a natural watercourse as a stream of water with defined bed and banks that flows for sufficient time to give substantial existence. It doesn't say or define what sufficient time is or substantial existence. We can all picture a natural watercourse, a river or a creek or whatever. Those are easy, but when they get smaller, it becomes more difficult. Does it flow for sufficient time to be considered a natural watercourse? And if it is, then there are certain things that result from that. If it's a natural watercourse, then the property owners immediately adjacent to the natural watercourse have a right of drainage. No one else does. Common misconception that everyone has the right of drainage. No, they don't. Only riparian landowners, owners owning land abutting a natural watercourse, have the automatic immediate right of drainage. Everybody else has to acquire it. This is an important thing in a province, especially with the snow that we see out there right now and the melt that's coming very soon. This is something that's really important to us because there isn't a right of drainage. And even your municipal roads, if you're draining onto adjoining property, you might be in a position of liability because you may not be a riparian landowner and you may not have the right of drainage, even though your water's going in that direction. So property owners, all property owners do some form of drainage, but not all of them have the right to do so and could be held liable if taken to court. So you could be, as I indicate there, could be held liable if you do channelization work or you remove natural obstructions like a beaver dam. You could be held liable, or if you create flow increases, or if a natural watercourse is relocated. So the takeaway from natural watercourses is only landowners abutting a natural watercourse have the right of drainage. And if you interfere with the natural watercourse, you could be held liable for damages. That's the common law, court decisions and case law. So the question that often gets raised is, so whose job is it to manage natural watercourses? And quite often I hear the answer is well, it's the Conservation Authority or Ministry of Natural Resources. I hear sometimes it's the municipality. And the answer is no. The answer is no one is responsible. No one has a duty to manage natural watercourse. So if there's a beaver dam on a natural watercourse, it's no one's duty to remove it. Somebody may remove it, but it's not a duty that is assigned to any party under common law. So here's an example. Here's a court case. Scarborough Golf and Country Club versus the city of Scarborough. There was a old golf course that happened. There was a creek that ran through the golf course. And the city, beginning in 1946, city of Scarborough started developing and creating houses and streets and roofs and all the drainage that associated with it. It went into this creek, and the golf course started to experience erosion. And channel kept getting wider. They put bridges over top, and finally they got sick and tired of it, and the golf course sued the city for damages and for an injunction for their interference with their riparian rights. The court's decision, the city was liable. They allowed development to happen that interfered with the golf course's riparian rights. And as a result of this court case, we now get stormwater management ponds and controlling the development or the flow that comes off of development. Now, this was a main instigator or reason why these stormwater management techniques have been developed is because of these cases, this case. Yes, sir.
Thank you, Mr. Mayor. So this is a classic example of something that is man-made situation because it was obviously development. I want to go back to your point about Beaver Dam.
Yeah.
Nature being a derivative of natural. So if a beaver puts a dam in the river, is that determined as natural at that point? Because it's not, that wasn't the natural water course. It was altered by, but it's altered by nature. So has that become a natural water course?
So there's not a lot of case law on that, but there's case law in BC. And before you say, well, that's BC, it doesn't apply here. The common law actually is used as the basis of law all across Canada and the US, with the exception of Quebec and Louisiana, which are based on the French legal systems. So BC uses the same common law that Ontario does. There was a court case where there was a natural water course. There was a beaver dam on that natural water course. It was in the interior of BC, so neither property owner lived there. The upper fellow used his land for farming. He grew potatoes or something like that. I forget exactly, but the beaver dam was flooding his land. So not the right thing to do, but he went onto his neighbor's property and removed the beaver dam. The neighbor got wind of it and sent him a letter saying, cease and desist, you aren't allowed onto my property. And the beaver built a dam again, as they often do in the same spot, flooded the guy's property, and he ended up suing his neighbor for damages. And the court determined that a beaver dam is a natural part of a natural water course, and the owner doesn't have a duty to remove it for the good of their neighbor. Not the answer we want to hear. Fortunately, most of the time people get along and try to resolve that, but there's not a duty. Now, that was in that specific set of circumstances. I don't want to say that that is going to apply for every situation, because it's the court, and you're somewhat at the mercy of the judges and the legal system. So whatever case they or points that they might bring forward might adjust something. But that's the only one that I'm aware of where they go, no, there's not a duty to remove it for the betterment of somebody else's property. And that becomes an issue. So, you know, you take the farmland that's flooded and instead make it a house. You know, somebody's basement is flooding and there's not a duty. Well, who's going to manage this? Well, the answer is nobody, which is not a great answer, especially if you're in BC, because they don't have an equivalent of the Drainage Act. Anyways, that's the natural water courses in a nutshell. So then you go to surface water, and that's got to be better, right? Well, under the common law, surface water is any water that's not contained within a natural water course. And what the courts have said is there's no right of drainage of surface water. So I say this for emphasis. It's not what the courts actually say, but the courts are basically saying surface water doesn't have the right to flow downhill. Fortunately, gravity still has the last say in everything, so it does flow downhill. But what the courts have said is if you're a lower landowner, you don't have to accept surface water from being directed onto you. You can build berms and dikes and stop the flow of water from coming onto your property. So again, you can think of 100 different situations in your municipality, including your municipal roads where road ditches drain into a low area and then onto somebody else's property. The courts are saying it doesn't have the right to flow there. Again, I don't want us to lose our common sense and say, yeah, that's going to happen in every case that we're going to start building berms and dikes, or the other aspect is if you collect it and concentrate it and discharge it onto an adjoining property, like a road culvert, if it causes damages, you could be held liable for the damages if it's taken to court. And collection examples I used, agricultural tile drainage, no question about it, but roadside ditches, storm sewers, stormwater management ponds. How about eaves troughs and downspouts? I dealt with property owners in Toronto where one guy directed his eaves troughs and downspouts onto his neighbor's garden. And you know, the fight ensued. So there's all sorts of aspects or all sorts of examples of it, but basically the bottom line here is surface water doesn't have a right of drainage. Fortunately, it often just happens because everybody knows water flows downhill, but if somebody wants to object, they can do so. So the other question about this, and I'm going to throw a condition on this. So what about longstanding water, like a road culvert, a cross culvert that drains onto an adjoining field? So the principle for years was if surface water has been collected and discharged onto somebody else and has been doing so for over 20 years, that's the Real Property Limitations Act that defines that 20-year period, then they can claim a prescriptive right of drainage. But I recently found out that with changes in legislation, they might have done away with that whole 20-year period and that whole prescriptive rights. So it might not even apply anymore. I'm not a lawyer. I've asked actually for some interpretation on this, but the 20-year rule may not apply. So if you have roads that are a similar situation to the picture up there, you might be in a situation where your roads don't, even though it's been going that way for a century, that you don't actually have the right of drainage anymore. The 20-year rule doesn't apply anymore. So that's the hand we were dealt with the common law. And when you think about it from a perspective of a, you know, Ontario being a land that is blessed with an abundance of water, but also with that comes an abundance of drainage issues, it's a real problem. I'm going to talk about this court case a little bit. This one actually happened in, I think it's Normanby, former Normanby Township, so not too far away from here. Two owners, Durbecker and Lynch. Durbecker had an old clay tile that outletted about 300 feet from the fence line, and from there it went on to the neighboring property, Lynch's property. But Durbecker decided to do some additional tile drainage work, and he outletted the new tile drainage work about 20 feet from the property line, and it started to cause flooding and erosion on the Lynch property. So Lynch approached his neighbors because there was, even though it was Durbecker that did the drainage, there was another neighbor involved as well. And he approached them and he said, how about we share in the cost of a ditch because I'm getting these damages. And according to the court case, Lynch said, yeah, Durbecker agreed to pay some towards the construction of the ditch. Anyways, Lynch built the ditch, went to Durbecker to collect a share of the cost. Durbecker said, not paying. I've solved my drainage problem. It's your issue. So Lynch said, fine, I'm going to block the flow of water. So he built a dam and he built it up large enough that it flooded Durbecker's land. So then the court case started. And the first thing they did was they reviewed the definition of a natural water course. And they said, no, we're not dealing with a natural water course here. There's no right of drainage. It's a surface water principal supply. Then the court said the original drainage that outletted 300 feet from the property line, it did have a prescriptive right of drainage. But because Durbecker added water, the new tile drainage, and outletted it onto the lower property owner, that did not have a prescriptive right of drainage. And so what the court said is, Durbecker, you're liable. And so the judge ordered that Durbecker install a pipe across Lynch's land, and Lynch had to remove the blockages after the pipe was installed, and then that Durbecker had to pay damages. Now that, takes several years to get through the courts, and both sides had their lawyers and engineers involved. And the interesting thing is that Durbecker never installed the pipe across Lynch's land, so Lynch never removed the blockage until 19 years later, when Lynch sold his property to somebody else. Then Durbecker approached the new guy and said, "You got any problem if we open up this dam here? You got a ditch there already." And the new owner said, "That's fine." My point is, courts are not necessarily a great way of solving drainage issues, but those are the rules that the common law applies. And it's because of the barriers or the restrictions of the common law that the province decided we need a Drainage Act. And they first passed the Drainage Act in 1859. It's been around for a long time because, again, the province realized that not having a tool to solve drainage problems is a barrier to the development of Ontario. And again, I focus on agricultural drainage, but it's not just that. It is roads, it is developments, everything that needs proper outlet. So it's a barrier to resolving drainage problems in a communal manner. And so that's why there is a Drainage Act. It's to provide property owners with a process or tools to solve drainage issues as an alternative to the courts. And there's two tools provided: mutual agreement drains and petition drains. And mutual agreement drains are they're basically a contract between owners. We agree to do this. So for example, Durbecker and Lynch, if Durbecker and Lynch had gotten along, basically Lynch had gone to Durbecker with hey, here's an agreement. Here's how I'd like to solve it. If you agree, sign your name to this contract. Ideally, you would register it on property title and it becomes binding to the land and problem solved. Durbecker didn't want to sign that agreement, didn't want to agree to anything. So that's why it ended up going to court. The other option is petition drains, which is what you're involved in now. So anybody have any questions on the common law? Yes, sir.
I think this is the right time to maybe ask this question as you're going to be moving on, it's getting more definitive for the day. You probably are familiar with that publication. It gets mailed to pretty well every agricultural farmer, farm families in Ontario. It is produced in Guelph, Ontario. And in this, it basically says this is a resource for all farm families. Go to this magazine, you'll find out what's not on. Sorry. So you'll find out what's available to you. So on tile drainage, in this publication for Ontario, there are 24 companies that are advertising I do tile drainage. Every one of them say that we use GPS and surveying of your land. All of them say that they have many years of experience. Most of them say that we leave your fields crop ready. This one says here, their job is not complete until disking services has been done as part of our standard installation. One says that they help municipalities with their issues of water. None of them say we will help guide you through the Tile Drainage Act. None of them say they can help you as the landowner if you wish to apply to OMAFRA for somebody to help you. Where is their responsibility in this process other than just give us a call and we'll drain your land? I believe they have a responsibility. That's why I'm asking. 24 companies say, give us a call and we'll drain your land. And then we can get into trouble. And they say we've got years of experience.
So first of all, I don't want to go down the path of tile drainage contractors too far. I would generalize it by saying everyone who collects water has a duty to bring it to a place where it's not going to do damage.
Okay.
Whether that is a tile drainage contractor with a tile drainage system, or whether it's a municipality putting in a culvert underneath a road, directing it onto their neighbor property, or whether it's a homeowner directing their eaves troughs and downspouts onto the neighboring property. There's a duty to take the drainage that's collected to a sufficient outlet. What happens when it doesn't happen? And that's where, again, the lower property owner has the right to, as I've indicated earlier, has the right to block the flow of water if it's surface water. They can't block a natural water course, but they can block the flow of surface water. They can initiate a lawsuit against whoever did that particular work. Or they can petition under the Drainage Act to try to get a solution to this problem.
Thank you, Mayor Kentner. Going back to the court case or Diefenbacher versus Lynch. They ordered Diefenbacher to pay, to
Yes,
do it, and he didn't.
and he didn't.
So it'd be another lawsuit.
Yeah, so normally when somebody doesn't abide by a court order, then you got to go back to court in order to enforce the order. In this case, it appears that Lynch was perfectly satisfied with keeping the dam up because the water was not coming onto his property, so he didn't care about going to court again to try to enforce the order.
Okay, second question. When you say a natural water course and the time of a natural water course, if a water course is 6 months of the year and then dry 6 months of the year, is that a natural water course?
I'm going to be evasive in this one because I don't have the answer. My guess is, yeah, it would be a natural water course, but ultimately it is a judge that decides that, not me. I can have my opinion. What I usually tell people is if it shows up as a blue line on some of the mapping, then somebody independent has indicated that in their opinion, it is a natural water course. That's as independent a judgment as you're going to get. It's not because I don't want to answer it. I can't answer it because there's no definition for sufficient time that I mentioned earlier. They didn't define that. So is it 3 months of the year? Is it 6? Is it 9? Don't know. I mean, I've seen rivers that have dried up during the summer, completely dried up. And yet there's very clear bed and banks. Does that make them stop being a river? I doubt it. But again, somebody's going to have to take that issue to the courts. And I want to stress, courts are not a great way of solving drainage problems. And Diefenbacher versus Lynch is a good example of it. Nothing got solved until roughly 20 years later. Okay, so therefore the Drainage Act was passed to resolve the Drainage Act process. It's a process that results in a municipal drain. All new drains are initiated by petition. I think that you've experienced that with this particular project. It's a legal document. The petition form is a legal document that initiates or triggers the Drainage Act process. And the signatories to a petition become financially responsible as soon as they submit the petition to the municipality and it's accepted. The other point I make here is the Drainage Act is not restricted to agricultural areas. It's often associated with agricultural areas, but it can be used to solve drainage problems anywhere. Any property owner can petition under the Drainage Act. We've had MTO petitioned for municipal drains to solve drainage problems. We've had developers needing an outlet for a new subdivision, and they petitioned under the Drainage Act for a solution. My recommendation always has been to council, be impartial. I've described your role as kind of like a referee in a hockey game. You're administering the process. You're not necessarily taking sides one way or another. Really, there are people that are property owners coming forward with a drainage issue. They're using a tool that they are legally entitled to use to find a solution. Your job is to administer the process under the Drainage Act. So again, that's a recommendation. Here's the validity of the petition. There are 4 things. Yes, Councillor Greenfield.
Sorry, Sid, going back to the former slide. Signatories to the petition become financially responsible as soon as they sign on the dotted line. Is it up to the various individual to in advance get some kind of estimate of the finances? Like, to me, signing up for something that you're financially responsible for, but have no idea what that dollar sign is going to be, that's pretty dangerous stuff, pretty risky. So is it the onus on whoever signs to do some advanced research of what may be financially involved before this ever starts?
Yes, thank you for that. It's a good question, and I do think it's on the responsibility of the petitioners to do their own research. They often view it, especially an agricultural property owner, is I can't afford the land if I don't have drainage, so I don't have a choice. I need to move forward. Where can they find data on what it's going to cost? Because if you ask an appointed engineer, the engineer will say, I don't know where this is going to go. I don't know anything about the project. I don't know how much fight there's going to be and how much time I need to deal with it. So I can't give you a hard cost estimate. The best place I would suggest is for property owners is to go to the Ministry of Agriculture, Food and Rural Affairs. Sorry, they have a name change. Ministry of Agriculture, Food and Agribusiness. And they have data on average costs. So it might be less, it might be more, but they might be able to get some data on what a typical project costs. Now, typical drainage projects can be as small as involving 2 property owners to being as large as involving thousands of property owners. So what's typical, and what's the cost associated with it? It's really difficult to say. But again, best place to get some information would be from OMAFA. So there's 4 things that make a valid petition. The majority. So the Act says if you have an area requiring drainage, if you have a problem area, there are 4 things that make a valid petition. Now, I want to be clear, the whole watershed is not the area requiring drainage. It is some area within the watershed that has a drainage problem. It might be a low area, and you can define it as a low-lying field that needs an outlet, or it could be a road that needs a legal outlet for their drainage. It could be a variety of different things, but the Act says there's 4 things that make a valid petition. The majority and number of owners in that low wet area, or the owners that represent at least 60% of that low area or area that has a drainage problem, or the Act gives special powers to a road authority. If a road requires drainage, you don't have a whole lot of choice about where you can bring your water. So the Act says you automatically, if you need drainage as a road authority, you automatically have a valid petition if you sign it. And then the last one is one that's never been used, the director of OMAFA, where if there's agricultural land involved. So that's what is what makes a valid petition and gets the process going. The next steps are council considers the petition. You've done this earlier. You can reject the petition, but you have to have a valid reason for it. You don't decide if the petition is valid. If council accepts the petition, then it gets circulated to the petitioner, to the local conservation authority, and any municipality or band council that might be involved. And there's some other recommendations about sending it to Ministry of Natural Resources and Forestry and Fisheries and Oceans Canada. So that's submitting the decision. Then council has to appoint an engineer, an independent engineer. And the engineer, right in the Drainage Act, the engineer must be fair and impartial. Again, they're representing not the petitioner, they're representing the whole watershed on what they think is right to solve the drainage problem and how the cost should be shared. It's also important to note that the engineer does not assign blame. He's not trying to act like a common law judge. The engineer is saying, here's the problem in front of me, here's how I'm going to try to solve it, and here's how I think, using the principles of the act, the cost should be shared. So if the engineer gets appointed by bylaw or resolution, that gives him or her the right of entry onto private land. And there's a whole guide for engineers that was produced by OMAFRA for engineers working under the Drainage Act in Ontario. And it covers a variety of different things like common law, but then the principles of the Drainage Act and the engineer's duties under the Drainage Act as well. First thing that the engineer does is has an on-site meeting where they review the landowner's needs, what the concerns are, and also the engineer has a duty to determine whether or not the petition is valid. So if it meets one of those 4 criteria, and if it does, then you move forward. So at this meeting, who gets invited? The owners within the area requiring drainage and every public utility or road authority that might be affected. And then I mentioned this, the engineer has to determine if the petition is valid. And what they often do is determine the needs and concerns of property owners and agencies. It's great if you can get the conservation authority there to say, we're concerned about this aspect of the potential project, or landowners saying, here's my concern, I've got erosion, or I need it deeper in order to have tile outlet. That's the whole purpose, to try to discover what you're trying to solve. There's a preliminary report. I don't think that was used in this particular case. It's an optional step in the process, and there's a meeting to consider the preliminary report. I'm going to go by this rather quickly. Then the engineer goes out and does a field survey. So they send the field crews out and they'll identify different features that they, where's the water flowing right now? What soils are in the area? They might do soil test pits. What other features are out there, like fences or buried utilities? And there's an opportunity to discuss the issue and the potential solutions with the individual owners as the surveyors are going along. So survey is done, and then they prepare a report. And the act says, here's what must be in the report: plans, profiles, specifications. So basically what you're saying is, here, property owners, here's what you're buying with this particular design. You have to describe the area requiring drainage. You have to provide a total cost estimate, an assessment schedule, and I'll talk about that in just a little bit. Allowances, which is compensation. So when a drain gets built, it occupies some land, and the municipality uses some other land in order to build the drain. And the property owners have to be compensated for that value, for the use of the land in order to build this communal drainage system. Has to provide benchmarks, provide details on how the materials are get disposed of, crossings, has to identify a working space. So all the things, these are all listed right in the Drainage Act itself, that these are things that the engineer must do. In addition, and this is a connection back to common law, the engineer must take the drain to a sufficient outlet. And I added a clause in there in most circumstances. The reason I add that is there is an allowance that can be given for compensation for bringing a drain to an insufficient outlet. Common example of that is rather than take a drain and dig it through a wetland area, you just take it to the edge of the wetland and say, that's it. It's not going to do a whole lot of damage to the wetland. We're contributing water to a wet area, so we're fine with that. So, but most of the time you have to take a drain to a sufficient outlet, and that's the connection back to common law. You can't take a drain to a point where it's going to cause damages to somebody else. The engineer considers individual property owners' needs. Now, sometimes those are conflicting interests. And so the engineer has to decide which way is the best way of dealing with the solution. Have to obtain any necessary permits and approvals. So from the Conservation Authority or Fisheries and Oceans, and usually works with the drainage superintendent and your municipal staff in order to come up with a solution as well. So working with landowners, working with municipal staff, working with the regulatory agencies, and working with the property owners.
Ask the clerk that.
I think considering today, we should welcome questions from the landowners too, and since we have Sid as a resource, I'm okay with it as long as you're okay with it.
I am for sure. Yep, and all council is.
Sure. Thanks. Sid, I just wondered if there's a schedule of procedure leading up to filing a petition for municipal drain. Like, do you just walk in and file a petition for a municipal drain, or is there steps you need to take prior to that?
So there's the response to that is there's nothing in the Drainage Act. Theoretically, somebody could just say, I've got a drainage issue. I'm not going to try to sort it out. I'm going to submit a petition. So that is possible, the possibility. The vast majority of cases that I have been involved in, the property owners have exhausted other solutions or potential solutions before they get to the point of filing a petition. And now, is that the case in this one? I don't know. But so is there a procedure? No. I listed some of the approvals that might be required. I won't expand on those anymore. So then they develop a plan. I'm going to show you an example. This is a tiny municipal drain. What happened was two property owners, this is a real life drain, but two property owners needed a drainage outlet. And the third property owner, the one right at the very bottom, refused to allow them access to the water course. And so they tried, back to your point, they tried to get a mutual agreement with the owner and he refused. They looked at the road authority, but it's in the MTO, it was Highway 6. And so they couldn't get MTO to cooperate. So they ended up petitioning for a municipal drain. So it is a pipe that is starts at the upper end, goes across a road, and then across the one property owner's land, and then across the very southerly property owner. So small drain, but you'll see the watershed boundary there. You'll see the location of the drain, the property ownership information, other features like roads and railways. They'll have a north arrow, so this is a typical plan, except it's a very small one. Then they'll also have a profile. In this case, this was the profile for the drain. It was part of it was pipe and part of it was channel. And it shows the grade, the slope of the drain. This is an exaggerated slope, by the way. It really doesn't flow at an angle like that. So, and they'll show different features associated with that profile. And then it has an assessment schedule. So again, this is a real life assessment schedule with 3 property owners and the road authority. And there's assessment types: benefit, outlet, and injury and liability. special benefit and special assessment against roads and utilities. I'm going to be covering these in more details because this is important information for Court of Revision members on understanding what the act says that must be assessed or how the costs are to be distributed. So I'll cover that in more detail later on, but the current report probably has a schedule similar to this, where it has land assessed and benefit and outlet liability and so on. There's also allowances. And allowances, again, are compensation that is given to a property owner for the use of their land, because the majority of municipal drains are built on private land, for which the municipality acquires a form of easement in order for them to not only construct the drain, but do any future maintenance or repair work on that drain as well. So in this case, there was an allowance provided to the property owner for the use of the land, and then also for damages that might happen to crops, et cetera, while the project is going on. So and that becomes part of the cost of the project, and the costs get distributed amongst the property owners again. Yes, sir.
Back to slides. Okay, so Matthew's just the one that wants the drainage done?
Matthews and Martin both wanted it.
Oh, so they both want it.
They
Okay.
both signed the
Counselor
petition.
Bartley, can you speak into the microphone just so we can hear your question?
Question again is, the top farm is the one that wanted drainage? You said no, the two of them did. I was wondering how it was forced on the expenses on the middle one, but he also wanted a drainage.
Yeah,
Thank
they both wanted to tile drain their land and didn't have an outlet. And they weren't prepared to outlet it into the roadside ditch, which would have been wrong under the common law. So they eventually felt they had no solution other than to petition for a municipal drain. They would have preferred to have done it by mutual agreement, but it didn't work. So then the engineer finalizes the report. This is not a mandatory step in the Drainage Act. A lot of the steps that I'm telling you about are defined right. Sorry, this is my copy of the Drainage Act. It's defined right in the act itself. This is not. This is an optional step that engineers often do to make sure that they're conveying what they're planning to do to the property owners and regulatory agencies as well, and then try to get some feedback and then polish up and finish off as best they can the report. So it's not an optional, it's not a mandatory step in the process. It's an optional one, but it's a useful one, and most engineering firms actually use it now. So then after that information meeting, the report is finalized and provided to the municipality. And then there's a meeting to consider the report, which I think was held not too long ago for this particular project. And at that meeting, a copy of the report and notice is sent out to all the involved property owners, any other affected property municipalities or band councils, and then regulatory agencies, road authorities, public utilities, and OMAFA, sorry. So then the meeting is held. All landowners are invited. It's chaired by head of council. The engineer gives an overview of the project, and the owners within the area requiring drainage, the problem area, the area that drove the petition in the first place, have a right to add or withdraw their names from the petition. If names are withdrawn to the point that it no longer meets one of the majority criteria, the project stops. And the original petitioners have the responsibility for the costs incurred to date. So when I said earlier, petitioners become financially obligated as soon as they sign the petition. If it stops, there's still a potential for them to have to pay the costs incurred to date. If it goes ahead, then the costs get distributed later on in accordance with the assessment schedule. So owners have a right to add or withdraw their names from the petition. Council has a role at this meeting as well. They can either decide whether or not to proceed. If they don't proceed, if they just leave it, you have the engineering costs incurred to date and you have no ability to recover costs. So normally council doesn't stop the project. Council can refer the report back to the engineer for modifications. And then the third option is council can give 2 readings to a bylaw, provisionally adopting the report. And that opens it up for the appeal stage. There are 3 appeal bodies. The first one is the Court of Revision, which is a municipally appointed appeal body. And I'm going to expand far more on that in just a little bit. But for now, just know, and this is information that you already know, the Court of Revision is a municipally appointed appeal body. In order to be eligible to sit on the Court of Revision, you have to be eligible to be elected to council. So it doesn't mean that you have to be a council member, but quite often council members are appointed. That's not uncommon. The second appeal body, and again, I'm going to expand more on this later on. The second appeal body is a long name. It's called the Agriculture, Food and Rural Affairs Appeal Tribunal. And for brevity, I'm just going to call it the tribunal. That's a provincially appointed appeal body, and they hear appeals, first of all, on decisions from the Court of Revision. So the Court of Revision members, whatever decision you make is appealable to the provincial appeal body. And they also hear appeals of more of a technical nature. So I don't like where the drain is located, or I don't like the size, or I don't think that the engineer has given me enough compensation for land taken, any sort of technical aspects. And there are sample court decisions on that website that are there. CANLI is Canadian Legal Information Institute. They have decisions from a variety of different appeal bodies, including the tribunal. So you can, if you want to read tribunal decisions, you can look at them there. The last appeal body is the legal appeal body. It's called the Drainage Referee, which is again a provincial appointment, and they deal with legal or procedural appeals. If somebody's going to the referee, you're arguing law. You might be arguing, I don't think the petition is valid. Which, believe it or not, is a legal issue. I don't think the engineer has properly defined the area requiring drainage and it doesn't meet the legal requirements, then you can appeal to the referee. And the referee deals with all legal matters. Basically, the referee is a judge that specifically deals with Drainage Act matters. And yeah, there's probably 1 or 2 cases across the province a year that goes to the referee. After all appeals have been heard, then council gives third reading to the bylaw, and that then authorizes the construction of the project, even potentially across properties that are opposed to the project. You still have to go through your municipal procurement process in order to obtain a contractor. Once the project's built, then your municipal treasurer, working with the engineer, will tally up all the costs and levy it to the property owners within the lands of the watershed. So it's doing the cost recovery bit. And then it creates new municipal infrastructure. So it is municipal infrastructure. You'll see that you have a duty to, or a responsibility to manage it. It has legal existence. So remember when I talked about a natural water course and a beaver dam and who's responsible for managing it? And the answer was nobody. If a beaver dam forms on a municipal drain, there is a duty. It's yours as a municipality. Not you personally as council members, but you'll have to send Jessica out to remove the beaver dams and manage the, I have no doubt. So the municipality has a responsibility to manage it. And that actually, I will go through a few of these slides quickly. So I know this is your first municipal drain, but again, once it becomes a municipal drain, this is your responsibility. Council, it actually says council is responsible for the management of the drains. And then it says hey, you can appoint a drainage superintendent to do that work for you. So that's where Jessica becomes involved. So what are you responsible for? Maintenance or repair of the municipal drain. I'll talk about each of these. I'll just slip to the next slide. Maintenance or repair, mandatory responsibility. Potential liability if you don't do your job of managing the municipal drains. They have to give notice that the drain is out of repair, and if you ignore it, then you could potentially be held liable for damages. You don't need a new engineer's report every time a drain requires maintenance. It would be your drainage superintendent going out and saying, yeah, this drain needs beaver dam removed, or this drain needs a clean out. We're just going to go back to the original plans. So an engineer's report is not required for every new maintenance or repair project. You have to follow the existing standards in the existing engineer's report that was adopted by bylaw. And costs are assessed proportionately based on the assessment schedule in the engineer's report. So again, everything's cost recovery. I should mention there are grants that are available, 1/3 grants for assessments levied on lands used for agriculture or assessed at the farm property class tax rate. Yes, Deputy Mayor.
Mr. Van der Veen, may I ask then, in terms of our responsibility, should we be inspecting these drains on an annual basis, or do we just wait until there's an issue that's reported by a landowner, or what is our role in, and as I think of our roads and bridges and so on, you know, we're assessing those on a regular basis. We do the same with these drains?
It's an excellent question, and I'm smiling because it's one that has come up so many times. I'm going to use Chatham-Kent as an example. Chatham-Kent is a large municipality, but they have over 4,000 municipal drains. They have 5.5 full-time drainage superintendents. That's all they do is manage municipal drains. And they don't have the time to inspect every drain every year. They rely on feedback from property owners. Now, drainage is such a way of life there that if there are issues, they know who their drainage superintendent is, and the property owners will identify that to their drainage superintendent. In your situation, when this drain gets built, you've got one municipal drain. I would suggest that you keep an eye on it to make sure that it's functioning properly. It's not so intensive like Chatham-Kent that you don't have the manpower to actually do it. There's also some municipalities that are using different techniques now to inspect municipal drains. They'll fly a drone out and see if there's any major issues like beaver dams or banks that are eroding or something like that. But I wouldn't suggest buying a drone for one municipal drain. I would simply suggest either talk to the property owners and say, if there's issues, contact me. It's our duty, it's our responsibility to manage it, or go out and inspect it periodically. But it's a question that has been around forever, because there's a lot of municipalities that go, we do not have the time to inspect every one of our drains annually.
Good question over here.
Thank you, Mayor Kentner. I don't understand why every municipal ditch is not considered a municipal drain.
So every municipal ditch, like a roadside ditch, is a municipal drain, but not one constructed under the Drainage Act. In order for it to be a municipal drain under the Drainage Act, it has to go through that process, culminating in a bylaw adopting an engineer's report. Your roadside ditch, you have no authority to clean out the roadside ditch and say, hey, property owners, here's your bill for your share of the cost because it's draining your land. What's your authority for that? You don't have a bylaw, you don't have an assessment schedule, you don't have plans and specifications. So in order for you to do what I think you're asking, and that is make our roadside ditches municipal drains, similar functioning to the Drainage Act, it has to go through that process. That's the only way to get there is, and again, it's easier when it's on your own road right of way, you have right of access. But what if your roadside ditch takes a 90-degree turn and goes onto your the neighboring property. You don't have the right, you as a municipality don't have the authority to go on to the neighboring property to clean out a private ditch. It has to be a municipal drain first. So there's real value in this, because you have the authority to manage a drainage system. And as I mentioned right off the top, as we get more snow or precipitation, it might be coming, and more development, as the mayor and I spoke about, it might become more and more important to have the tools to manage these systems in the future. But just because it's a roadside ditch doesn't make it a communal drainage system. I consider a roadside ditch to be a private drainage system built by the road for the road, nobody else. Okay, there's abilities to do improvements to municipal drains. I'm going to skip this because that's usually like 50 years down the road. So I'm not going to worry about that right now. There's different types of improvements. You have the information, but I don't want to focus in on it right now. I do want to talk a little bit about other management responsibilities. So when you have a drain that's built, there is a watershed. That's that red line on your plan. And I consider the wording that I've used is the owners of the land within that red area are the co-owners of the drain. They're not really co-owners, but they're co-financiers of the drain. What happens if somebody severs a property? The assessment schedule doesn't show that. While there's tools in the Drainage Act that, as part of your management responsibilities, you would update the assessment schedule, the cost sharing schedule, to deal with severances. What if somebody decides that they're going to take an 100-acre agricultural property and develop it and put houses on it and streets? Well, all of a sudden they're going to be generating significantly more water. And what the act says is, hold on a second. Number one, you got to get permission from council to do that. And number two, if council gives you permission, you're going to be contributing more water. Your share should be higher than it was before. So there's, again, tools for dealing with that in the Drainage Act. And there's also a tool for updating the whole assessment schedule. What if somebody comes along and says, I don't like this drain on my property, I'm going to just fill it in? Well, there's an enforcement tool for blocking a municipal drain. What if somebody says, I don't like where this drain is located, I'm going to divert it around the edge of my property and do with it as I want because it's on my land? Well, it's a municipal infrastructure for which the municipality has a bylaw. If somebody rerouted or damaged a municipal drain, there's tools for enforcing the damaging of a municipal drain as well. So there are tools to manage the municipal drain into the Drainage Act. You also have a tool for abandoning the municipal drain, which you haven't created one yet, so we're not going to talk about abandonment.
Mr. Mayor, if I may, does impact give any consideration to whether or not there's a drain added to a property? Does adding a municipal drain then increase the assessed value of said property?
To my knowledge, no. I do know that they take into consideration whether or not a property, an agricultural property, is tile drained, but I don't recall ever seeing them taking into consideration whether there's a municipal drain on the property. To my knowledge, again, things might have changed, but I don't think so. Drainage superintendent, appointed by bylaw, right of entry onto land. Normally a person is appointed, but it can be a company as well. So in your case, obviously Jessica is your drainage superintendent. Superintendent's duties: maintain and repair drains, inspect drains periodically, manage drains on behalf of council, provide council and staff with advice on drainage matters, provide property owners with advice on drainage matters. And again, similar to the engineers, OMAFA has produced a guide for drainage superintendents, and I think Jessica has a copy of this, if I'm not mistaken. So why the Drainage Act? Really, the first one is the most important one. It's a process to solve common law drainage problems. I've used the line before, if we wouldn't need a Drainage Act at all if people just got along. But the reality is it doesn't happen. There are conflicts around drainage, happens all the time. And that's why the province, I passed the Drainage Act and provided that tool. Professional design by an independent party. The engineer must be independent, impartial. There's a section of the act that specifically talks to that. And make sure that there's compliance with legislation such as CA Act or the Fisheries Act or Endangered Species Act or whatever. Independent cost sharing recommendations, which is important. I mean, there's a lot of drainage that would get done if somebody's willing to pay 100%, but quite often somebody says, well, hang on a second here. If I pay 100%, you're benefiting from this too. So that's part of the issue, is cost sharing. Independent appeal bodies, that is of value to property owners in resolving drainage issues. And for the municipality, you have a right of entry onto land, you have a right to recover your costs, and you have a right to entry onto land also for future maintenance or repair. So that's the advantage, or why the Drainage Act is used. So now I want to get into the quarter revision training, unless anybody has any questions on this part. Okay. Alex, I think I shared this, right? Did they receive copies of this? Okay. Okay, there is a fact sheet called Understanding Quarter Revision Procedures under the Drainage Act. It's really intended for members of the Quarter Revision as a bit of a resource. So I'm going to talk about the description of the quarter revision. I'm going to talk about the authority and the composition of the quarter revision. And then I want to get a little deeper into assessments, and then grounds for appeals, filing appeals, and the suggested hearing process, and then decisions. So again, if you have any questions throughout this, by all means, I'll do my best to answer them. Yes, Deputy Mayor.
Through you, Mr. Mayor, may I ask Alex if it's possible to have that copied for us anyway that are going to be on this panel? Thank you.
Okay, description of the quarter revision. You are a municipally appointed appeal body. What does that mean? You are appointed by council. Let's use the planning tribunal as an example. The planning tribunal is a provincially appointed appeal body. They hear appeals, they make decisions. They do not report to the province on their decisions. The province can't override it. There's appeal mechanisms on decisions, but they're totally independent. The quarter revision is the same way. You are an independent appeal body. You're appointed by council, but you don't report to council. Council doesn't have to approve your decision because you're an independent appeal body. So there you go. You don't report to council. Council cannot change a quarter revision's decision because, again, you're an independent appeal body. You're considered a tribunal under the Statutory Powers Procedure Act, which basically means you have to be, there's a whole lot of sections, but basically it means you have to be fair and impartial, and there's rules around holding hearings in person or remotely or by telephone, all these sorts of things under the Statutory Powers Procedure Act. But the bottom line here is you're an independent appeal body. Yeah, and I use these comparables as well. Ontario Land Tribunal or the Agriculture, Food and Rural Affairs Appeal Tribunal. So keep that in mind. I added the definition there. Under the Statutory Powers Procedure Act means one or more persons, whether or not incorporated and however described, upon which a statutory power of decision is conferred by or under a statute. So that's exactly your situation as quarter revisions members. You have a duty under the Drainage Act to hear appeals on assessments, which we'll talk about in a little bit. Yes.
each, not that it's likely to happen very often, but each time an appeal comes to the municipality, there is a new court of revision appointed, or does the one that is appointed continue for the term, or how does that work?
Excellent question. And I'll say different municipalities deal with it different ways. So I'm going to go back to Chatham again, Kent again, which probably does about 40 or 50 new engineers reports every year. They have a standing board that sits as court of revision, so they don't have to appoint new court of revision members every time. In your situation, I would suggest that the court of revision be appointed individually for every drainage project. You might not have one, you might not have more than one a year. And maybe you want to share the experience with, have others have the opportunity to share in the experience as well.
Sid, could I ask, what if today happened to be a snow day? Just imagine it. The point is, can these meetings be remote or hybrid, or what was decided on that issue?
Statutory Powers Procedure Act, yes, they can definitely be held virtually. I know that the tribunal, the Agriculture, Food and Rural Affairs Appeal Tribunal, actually holds most of their hearings remotely now. And again, I draw the comparison of the Court of Revision to some of these provincial tribunals as well. They're both decision-making bodies. Because it is a local appeal body, to me, I would recommend that be not the default position. You'd much rather do it in person, but by all means, if it's bad weather and people want to go ahead, you could do it remotely or virtually.
Thank you.
So authority and composition. So authority, you hear assessments on appeals on assessments for new drain projects. And then I glossed over drain improvement projects, but that's another situation where a court of revision would be set up. And again, I didn't focus in on that or the new assessment schedules. But anytime there's a new engineer's report, then there's likely going to be a court of revision. There's a couple of sections in the act that there's an engineer's report, but it doesn't involve one of these three. But any of these, you would hear appeals on assessments for these matters. So in this one, we're talking about new drain projects. Composition, this comes from section 97 of the Drainage Act. 3 or 5 members appointed by council. So if the 3 of you are sitting as a court of revision, you are complying with the act. If there was another municipality involved, because drainage projects, water doesn't respect property boundaries or municipal boundaries. So there are drainage projects that have involved multiple municipalities. If you've driven on Highway 400 and you go through the Holland Marsh, the whole Holland Marsh straddles a region and a county and 2 different municipalities. And so they set up a joint court of revision between the different municipalities. So when there's more than one municipality involved, 2 from the initiating, 1 from any other one. And again, in order to sit on the court of revision, you have to be on council or eligible to be elected. So a resident, I guess, not an employee. That's the composition. Types of assessment. And this is where I'm going to spend a little bit of time on what's in the engineer's report in terms of assessments. So some of what the next slides are actually from the Drainage Act itself. So when the engineer does a report, the engineer must comply with these sections of the act. So here it is, section 21. The engineer report shall assess for benefit, outlet liability, and injury liability, and shall insert an assessment schedule. So that's why you have that table. The sums assessed for each opposite each parcel of land and road. Okay, so let's take a look at benefit liability, benefit assessment. And again, this is right from the act itself. Lands, roads, buildings, utilities, or other structures that are increased in value or more easily maintained as a result of the construction of a drain may be assessed for benefit. And then there's a definition for benefit in section 1 of the act, and this is the exact wording, means the advantage to lands, roads, buildings, or other structures. It basically is a repeat. One thing that I want to point out is benefit is usually assessed to the properties immediately adjacent to the drain itself. So if you have a drain that is 1,000 acres in the watershed and your actual drain only affects 2 properties, there are other properties that don't actually benefit from the drain and wouldn't actually be assessed benefit. So it's only the benefit, usually the properties in the immediate adjacent area beside the drain or has direct access to the drain that would be assessed for benefit. It's benefit to lands, roads, buildings, or utilities, and so on. It doesn't have to benefit the owner. I've had somebody before, somebody who bought an agricultural property, but was a speculator from Toronto. They had no intention of farming the land. And so they said, this drain doesn't benefit me. And the answer is, it's not about you, does it benefit the land? Would the land be of value if a future owner decided to buy this land and use it for agriculture? Is there an advantage to them? Is it an advantage to the land? And by having a municipal drain that provides an outlet, many property owners would say, yes, I now have a legal outlet in order to discharge my water. I have a sufficient outlet, so I have the ability to override my common law responsibilities. So it's the benefit to the lands or roads. So usually when the engineers look at this, they look at, is there an advantage to the lands that are getting this drain? And remember, the engineer doesn't assess blame. The engineer is not a court. It isn't a judge saying this person's responsible or not. The engineer is looking at the situation today and saying, we have problems here. If we build this drain and fix the problems, who benefits from it? And using these principles right here. So keep that in mind in benefit assessments. Second one is, and this is the second main one, is outlet liability. And it's interesting that the Act uses the term liability. From my perspective, this is a connection back to common law. Remember, surface water has no right of drainage. And if you discharge it onto your neighboring property owner, they can put up berms and dikes and this sort of thing. So you have no right of drainage, but what the Drainage Act is saying is, if we build this drain and we assess you an outlet liability, you are buying a right for your water to flow downhill through the drain. That's what you're getting. And so what the Act says is, if you use an outlet, either directly or indirectly through the medium of any other drainage work or swale, may be assessed for outlet liability. Now, the Act also defines it. I find that the definition doesn't help a whole lot, but the 23(1) certainly helps. Then the second one is injuring liability. If from any land or road water is artificially caused by any mean to flow upon and injure, then it can be assessed for injuring liability. And again, there's a definition there. So what has happened over time is, I should finish off with the last one here, the basis of assessment. The assessment for outlet liability and injuring liability shall be based upon the volume and rate of water artificially caused to flow upon the injured land or road. Okay, so what does that mean? If you are draining land downstream, you get assessed and into this municipal drain, you get assessed based basically on the amount, the volume and rate of water that your land is generating. So if you have, picture an acre of parking lot and an acre of agricultural land and an acre of road, and then an acre of bush. The acre of parking lot is going to generate far more water, both volume and rate. And so it would be assessed at a much higher rate than the acre of agricultural land. And the acre of road would be assessed higher than the land, than the agricultural land, but less than the parking lot because there's ditches and there is some infiltration that happens. So it's based on the amount of water that's generating off of that land and into the drain. So that's what the act says. Now, I want to go back to outlet and injuring liability. Outlet liability and injuring liability, they're different, but the calculation are exactly the same. If you read this right here, outlet and injuring liability are based on the volume and rate of the flow of water artificially caused to flow upon the injured land or road. So over time, and this has been supported by the appeal bodies like the tribunal and the referee, the engineers no longer are rarely distinguished between outlet and injuring liability. They just put it all under a column called outlet liability because the calculation is exactly the same. So it's based on the amount of water. So anytime I dealt with property owners who said, I shouldn't have to be assessed at all because I don't benefit from the drain. And I go, yeah, you don't benefit from the drain because you're a kilometer away. I shouldn't have to pay anything whatsoever. I said, does your water go down there? Yes, it does. Well, then, yes, you do have to pay based on this volume and rate of water artificially caused to flow upon into this drain. So again, the engineer will base the assessment on the land use. So how much land of that property is going into the drain and what's the land use? So for example, if a property, 100-acre parcel of land, let's say all of it was going into this drain, but the 100 acres was made up of 50 acres of bush and 50 acres of agricultural land. The engineer will delineate and say, okay, I got 50 acres here of the agricultural land. It's going to be assessed at a higher rate than the 50 acres of bush, which doesn't generate water at the same rate. So those are the sorts of things that that the engineer will take into consideration when developing the outlet liability assessment. Yes, sir.
Mr. Mayor, so yeah, I'm glad you said that because I was gonna ask for clarification. So because your preceding statement said that it's based on the potential improvement of that property, even if you're not farming it now.
The benefit assessment, yes.
Correct. So if that happened to be in that 50-50 proposition, theoretically, the bush territory was not being farmed at that point. So it's the engineer looking at the scenario as it exists now, because theoretically, somebody could clear that bush and make it agricultural land in 10, 20 years.
Yeah.
And it could be a benefit for that down the road. Is he looking at that, or is he only looking at as it exists now?
So keep in mind, benefit only gets assessed to the properties that actually have a direct access to the drain for the most part. So if I'm talking about a property now that is a kilometer away from the drain, but they're in the watershed, they could clear their land, but they still don't have direct outlet to the municipal drain. They don't have direct access to it because the drain's not on their property. They're just in the watershed. So if they clear their land, they should be assessed more, especially if they somehow manage by, let's say, agreement, they cross somebody else's land and connect into the drain, then they can be assessed for, they should be assessed an increased amount. So I'll go back to my example when I talked about drain management. Let's say you have a 100-acre parcel of land and somebody decides to develop it, houses, streets. You're going to generate more water. The volume and rate of water, as shown in this slide right here, is going to increase. What the act says is if you're making greater use of the drain, then you should be assessed a larger share of the cost. So there's tools on managing land use changes that come in the future. But for now, what the engineer will do is base it on what's there right now today. So again, I've covered this because the principles of outlet and injury liability are the same. Engineers usually list everything under outlet liability, and that's been accepted practice by the appeal bodies. Lands that contribute water into the drain are assessed for outlet injury and liability. And again, some of these drains, these lands may not benefit from the drain. The way I've described it before is you may not benefit from the drain, but your water now has the right to be there. And so again, it's overriding some of the principles of the common law where surface water is no right of drainage. So now your water has the right to be in that drain. That's what you're buying. Some lands will be assessed for both benefit and outlet liability. Okay, then the next type of assessment is special benefit. I don't know if there's that in this particular report, but our special benefit gets assessed to lands that have some sort of a feature that is not for the good of the community of landowners, but it's for the good of that particular property owner. For example, I'm going to use this as an example. If a drain dissects a property, the act says you got to provide them a crossing so that they can access the back of their land. If the property owner says, I'd like 3 crossings, well, the first one gets cost shared. The second 2, I would consider to be special benefits. These are additional things that you want, but the drain doesn't really, the drain community shouldn't have to pay for. So those are called special benefit items. Any additional work or feature included in the construction or repair or improvement of a drainage works that has no effect on the functioning of the drainage works. So special features. Again, I don't know if any of those are in this report. This is not, I don't think this drain involves a road, right? So I'm not going to worry about that right now. This is specifically for roads or public utilities. So I'm going to skip by that. Okay, so here are the grounds for appeals. There's 3 grounds for appeals to the Court of Revision. Any land or road has been assessed an amount that is too high or too low. Usually the appellant is saying my land is being assessed too high, and they'll identify somebody else that should be assessed too low. One of the things that you need to take into consideration is they might compare one number to their land and go, it's not fair. But things that need to be taken into consideration is, do they have the same amount of land in the area? Are they also looking at both benefit and outlet? And what is the land use? Again, if you had 2 equal 100-acre parcels of land, but one is all bush and the other is all agriculture, the agricultural property should be assessed more because it's generating more water off of that land. Second one, land or road that should have been assessed has not been assessed. So somebody comes forward and says there's lands in the watershed that the engineer has totally missed. And if that's the case, it's, first of all, how could that happen? Quite often it's one crossing under a road that got missed. And that crossing under a road adds another 100 acres to the watershed of the drain. When this occurs, then usually the Court of Revision would say those lands should be assessed, or we're going to adjourn and engineer, we'd like you to investigate this and report back at the next sitting of the Court of Revision. And so it doesn't happen that often that land that shouldn't have been assessed has not been assessed. There's quite a bit of technical tools that are available to define the contributing area quite accurately. Third grounds for appeal is due consideration has not been made to the type of use of land. So what does that mean? The engineer based his calculations that my land is used for agriculture and actually it's used for bush. And so I should be assessed at a lower rate. So not proper consideration of land use. And again, if that's the case, then you make some sort of an adjustment to the assessment. So this is a consideration for outlet liability. And I use that example well, I use the example of bush, but it should be residential when the engineer assessed it as agricultural. So those are the three types of appeals that can be heard by the Court of Revision. Sometimes the Court of Revision will hear all sorts of other types of appeal, like allowances. My allowances are too low. I should be given more compensation. The Court of Revision does not have the authority to deal with that. You only have the authority to deal with these three grounds, only those three. If somebody wants to challenge their allowances, that has to be taken to the tribunal. Filing appeals. So this has all happened already in this particular one, as far as I understand. Provisional bylaw and notice of the Court of Revision is mailed 20 to 30 days before the hearing. And the appeals have to be filed a minimum of 10 days before the hearing. Suggested hearing process. I might change this a little bit. So you would open the Court of Revision, remind the audience of the grounds for appeal, request the clerk to identify appeals filed within the specified timelines, identify any late appeals. And the Court of Revision, I recommend that you also decide whether or not you're going to hear appeals verbally. Some Court of Revisions do. So nobody filed an appeal and you're just going to hear it verbally. And you have to decide, whether or not you're going to hear these late or verbal appeals. Schedule of appeals is created. Now, if in your case you have one, the schedule is easy. I would recommend that the chair of the Court of Revision read out the appeal that's been filed. And then the engineer will give the overview of the assessment principles. So the engineer has to give evidence first. That comes from Section 55 of the Drainage Act. And the engineer would then specifically talk about the appeal or the assessment against that particular property. And then the appellant presents an appeal. If the appeal is to reduce an assessment, the appellant should identify who that reduced assessment should go on. So for example, your job as Court of Revision, you can't change the cost estimate of the project. So if you're going to reduce one person's assessment, you got to add it to somebody else. The total cost has to be the same at the end of the process. So if an appellant says my assessment should be reduced for the following reasons, and I think it should be added to X, then that has to be identified. Then if the Court of Revision, the property owner identified by the appellant is not in attendance at the hearing. So for example, I say that my assessment should be reduced, but Alex's should be increased, and Alex is not present, then the Court of Revision has to adjourn. Don't make a decision because you've only heard one side of the argument. You would adjourn, send out notice to Alex in this case, and then Alex has an opportunity to appear before the next sitting of the Court of Revision where she would present her rebuttal, and then you would make your decision. So there's a responsibility to adjourn and reconvene. And the second sitting of the Court of Revision is not to hear new appeals. It's only to deal with the rebuttals that Alex might present. Yes.
Why would not, I know it's not like a normal court, but why would not both parties kind of be required to be there? Because it obviously can create a scenario where we now have to do it twice. So why are they not required to literally both be there?
Yeah, great question, and I don't know the answer to that. What I'm telling you is what it says in the act. So, sorry, I don't have a great answer for that. I do know that some people have to take time off of work, and if you looked at the report and you go, yeah, I'm satisfied with my assessment, I can live with it. You might not decide to take a day off of work in order to attend the Court of Revision, and then this happens. So, but it's a good question. One that should be directed to OMAFA, not to me.
Then,
Yep. Sorry.
I just add to that comment about deferring the decision. If there is no change in the assessments in the engineer's report, the court can make a ruling that day,
Right.
correct?
Yeah.
So it's only if there is going to be a change in the assessments and the landowner that's affected by the change is not present, do you need to
Yes.
reconvene? If there is no change, you can make your decision and move forward.
Yes, good point. Thank you for that.
So what happens if it happens 3 times and 4 times and 5 times?
Only happens once. So if the person decides not to show up for the so I appeal and say it should go on Alex and Alex chooses not to show up, you drive on. It is to give the parties involved an opportunity to provide a rebuttal. If they choose not to use that right, drive on. Court of Revision makes its decision and carries on. Yes.
If an appeal is launched by one party, one petitioner to reduce their assessment. And the reduction is suggested that it be against petitioner B or 2.
Right.
And that petitioner is not present. So it's just simply an automatic deferral. Does the person who is not present have a time limit to contact the Court of Revision and say, hey, look, because I don't know why they wouldn't want to question the appeal or argue it, but if they're not there, I mean, how long is there a time limit? Do we have 10 days, 30 days, or it's easy to defer the decision, but what time limits are, or is there a stipulation?
So good question. The act does not specify a time limit. I suggest, or I recommend that you use the same time limit that for the initial one, which was appeals have to be filed 10 days in advance. So again, if I appealed that my assessment is too high and Alex, it should be lowered and Alex is increased and Alex is not present, then what I would do is give Alex notice, 10 days notice for a reconvened Court of Revision. So it doesn't last indefinitely. And Alex's choice would be show up or not show up. And if you reconvene and she's not there, then you make your decision. If she is there, you hear her arguments and then you make your final decision. Okay. So again, a lot of this I just covered here about the adjourning and reconvening. Again, opportunity for rebuttal. Okay, I want to talk a little bit about sample decisions, and it also gives you some ideas of some of the sorts of things that can come to a Court of Revision. So first one, whoops. Here's a sample decision. Assessment should be lowered because a portion of the property drains into another municipal drain. Decision should be reduced by 2/3 from $300 to $100 and the difference be added to the municipal road authority. Well, that's not an option in your case. You don't have a municipal road that is assessed into this drain, but that's a appeal summary and the decision. Another one. The crop damage allowance is insufficient and should be increased. And the decision should be the appeal is dismissed because it's outside the jurisdiction of the Court of Revision. You don't deal with allowances for compensation, just assessments. And the property owners can appeal their right to the tribunal. Third one, the assessment should be lowered because the engineer has calculated the assessment based on 100% agricultural use. Actual use is 50% agricultural and 50% bush. And if that is in fact the case, then the property you can decide that the property should be reduced by $300. We just use that figure, and the reduction should be added to the assessment on property, whatever. The owner of this property was present at the hearing, so you can add it, or give them an opportunity to do a rebuttal or whatever, and then you can make your decision. Here's another one. Assessment should be lowered because the owner has no intention of using the land for agricultural purposes. And that's one. Appeal is dismissed. The property still has the potential to be used for agriculture. And so it does benefit from the drain. That's the point that's being made. You will hear that I don't benefit from this drain and therefore I shouldn't be assessed. It's the property. Appeal summary: assessment on all private properties should be reduced, and the environmental agency, I've heard this one before, should be charged $5,000 for the additional costs of studies that were required. Well, you can only adjust assessments between assessed property owners, and if the appeal body is not an assessed, if the environmental agency is not an assessed owner, you can't just arbitrarily put money on somebody else. So it should be dismissed. I think that's it. Okay, no, I do. Oh, yes, sir.
Thanks. Just gonna go back to that point. Just, and looking at the actual notice of appeal form that we received, how did point 2 and 5 get appealed? Because they weren't really options to be appealed.
So decision, the appeal number 5, environmental agencies and compliance with environmental law are a part of every project. So if it costs $5,000 more, that gets added to the project. There is no appeal right. You must comply with law. And if the Conservation Authority or Fisheries and Oceans imposes some things, that becomes part of the cost of the project. There basically is no appeal right. I want to go back to number 2. Crop damage allowance. I indicate the answer in the decision. The property owners have the right to appeal their allowances or compensation to the tribunal. That's the appropriate authority that can hear those types of appeals. I mentioned this earlier. Court of revision decisions can be appealed to the tribunal within 21 days of the pronouncement. So quite often when you have, you sit and you hear an appeal, after you've made your decision, you would pronounce it verbally. I recommend that you follow up with a written decision as brief as what I had shown up there, but pass something, issue some sort of a written decision. And then that's the 21 days from that point, from when you verbally indicate the decision, that's when they have the right to appeal to the tribunal. And then you close, pass a resolution to close the court of revision. And that's it.
And if a decision is appealed, what happens next?
If the decision is appealed, if the Court of Revision's decision is appealed to the tribunal used to have a Latin word, trial de novo. It would completely start from new. So if you make a decision, not only could the tribunal reverse it, they could increase it or they could decrease it. From the original. So so the tribunal is going to deal with it as they feel is appropriate. The tribunal is composed of usually 3 panel members, and one of whom must be an engineer, must be a lawyer. The second appeal member is usually an engineer. It's been a long time since I have seen a panel that didn't have an engineer on it that's experienced under the Drainage Act. And the third one is a farmer or former municipal councillor or somebody with other background that sits on the panel as well. So they would hear it completely new. The Court of Revision doesn't have to go to the tribunal to defend their decision.
Thank you. Any other questions for Sid? Could we have a recess between now in the beginning of the meeting.
Thank you, Mr. Mayor, through you. Because we're sort of at the end of the training, I would recommend if there's no questions, we can just move to adjourn and there'll be a little bit of time before the Court of Revision. There's so we can take a break in between.
Okay, so I need a motion to adjourn. Councillor Bell, a seconder, Deputy Mayor Cubany, and I declare this meeting adjourned. All in favor?